Hey everyone, today we are going to talk about garden leave. Garden leave is a period during which an employee who has resigned or has been fired is still employed and paid by the company but is instructed not to perform any work or to go to the workplace. Essentially, the employee remains on the payroll but is prevented from actively participating in the company's operations. This clause is commonly found in employment contracts, particularly for senior employees or those with access to sensitive company information. The primary purpose of garden leave is to protect the employer's business interests by ensuring that the departing employee does not take advantage of inside knowledge, client relationships, or strategic plans before officially joining a competitor. In many ways, the garden leave clause functions similarly to a restraint of trade clause. While non-compete clauses explicitly prohibit employees from working for competitors after leaving the company, garden leave ensures that employees remain contractually bound and inactive during their notice period. This effectively delays their ability to move to a competitor while also preventing them from using confidential information to gain an unfair advantage. By keeping the employee away from clients, colleagues, and ongoing business deals, the company minimizes potential disruptions and safeguards its competitive position. From an employer's perspective, there are clear advantages to including a garden leave clause in employment contracts. It prevents employees who resign from immediately working for competitors, giving the company time to implement succession plans and to retain valuable clients. Garden leave clauses could also help protect trade secrets, ensuring that sensitive information does not transfer to rival competitors. However, there are drawbacks. The company must continue paying an employee who is not contributing to the business, which can be costly, especially for long garden leave periods. Additionally, enforcing a garden leave clause could lead to legal disputes, particularly if the employee challenges its reasonableness. If an employee on garden leave secretly works for another company, there can be serious legal consequences. Since the employment contract remains in effect during the garden leave period, the employee is still subject to contractual obligations, including duties of fidelity and confidentiality. Secretly working for a competitor during this period would likely constitute a breach of contract, exposing the employee to legal action, including claims for damages or injunctions preventing them from taking up the new role. In some cases, companies may also withhold remaining salary payments or take disciplinary action. The enforceability of garden leave clauses have been upheld in English courts. In the case of J.M. Finn and Thomas Brooke Holiday, the High Court of England upheld a 12-month garden leave clause, emphasizing that such clauses are enforceable as long as they are reasonable and protect legitimate business interests. This decision illustrates that courts are willing to recognize the necessity of garden leave in certain industries, particularly where client relationships and confidential information are at stake. Whether a garden leave clause is necessary or merely optional depends on the nature of the employment. In industries where employees handle highly sensitive information or maintain close client relationships, a garden leave clause can be a crucial safeguard. However, for roles where there is minimal risk of confidential knowledge being transferred to a competitor, such a clause may not be essential. Employers must carefully assess whether the inclusion of a garden leave clause is justified and ensure that it is reasonable in duration and scope to avoid potential legal challenges. Garden leave strikes a balance between protecting an employer's legitimate business interests and ensuring that employees are treated fairly during their transition out of the company. While it can be an effective tool to prevent the immediate transfer of knowledge and relationships to competitors, it should not be overly restrictive or punitive. Courts will scrutinize these clauses to ensure that they do not unreasonably limit an individual's right to work. Companies should therefore draft garden leave provisions carefully, considering the specific needs of the business and the role of the employee. Thanks for joining me in today's video on garden leave. Don't forget to like, share, and subscribe, and I'll see you in the next video.